¿Qué más, ingeniero?
Los últimos en recibir esas vacunas. ¿Por qué digo que analizar la figura del arbitraje en su conexión con el rule of law es importante? Cuando un inversor extranjero se plantea invertir en un determinado país, y eso los que hemos estado o están en firmas que se dedican a la abogacía de los negocios, una de las primeras cuestiones que plantea es: ¿ese país donde voy a invertir proporciona seguridad jurídica o no proporciona seguridad jurídica? Si no proporciona seguridad jurídica, la posición del inversor es no invertir en ese país, porque la alternativa es acudir a los tribunales locales, y en unos casos sí, pero en otros no. Esos tribunales locales no garantizan la seguridad jurídica, no garantizan el rule of law que este inversor está buscando. La evolución en materia de protección de inversiones extranjeras ha pasado desde que en el siglo XIX, cuando a alguien le expropiaban, si era un inversor importante, pues el país al que pertenecía el inversor mandaba a sus ejércitos, a la ruptura de las relaciones diplomáticas y finalmente a lo que supuso una estrategia.
And obviously, yeah, the agreement regarding differences, civil investments, and some other states as well. And it's the ICSID agreement. It was effective in 1986 in October, and in today they have ratified it. Many agencies ratified it. That's the mechanism of CID. That's fundamental to guarantee some investments. And when we're talking about countries, underdeveloped countries, but in Africa, well, many countries got kind of very small development, so there's no interest in the development. So we're going to talk about the rule of law, the arbitrage. This parliamentary story is very good for investments in Africa. So that's the point. We have two very famous lawyers around here and some other foreign lawyers I'm going to talk about. Irma Rivera is the partner of Brigard Urrutia. It's the person that litigates people that have no money, and also the insurance. Irma has a degree. She's got plenty of experience. She has got many different clients, foreign clients as well, and she is an international national for for conciliation in Cali and Medellin. She is a professor at Universidad Sergio Boleda regarding alternative methods for a conflict resolution, and we are happy to say that she's just right here with us. To my left, right here, is Daniel Posse. Daniel Posse is from Posse Herrera Ruiz, and is the person that liderates conflict resolution. He has been practicing very much. Is a very important figure in arbitrage in Colombia. But yeah, the person is just so much happy to have us there. They're connected in video conference. As a person regarding uh, investments, that's the one I was talking about. I was telling you I was incorporated in this institution. Uh, Share agreement. There was fantastic chairman Salami in Paris. He worked there and it's, he was building African art and also the person in charge of many important things in Africa. We have right here. Uh, it's the very important person for disputes in Paris. Is a partner there. We have this arbitrage department. He's called there in this ambience that is very important. Europe, Africa. He is also a lawyer and as a ref uh, actions, collective actions. So we've had Jamal here. He's done many things. Arbitration in the Arab countries. That's something he did. Um, so the continent that was in the continent that was very good for us. Sorry about the interruptions. Marshall Akakpo and Associates. Uh, he's a doctor by Nisa University. Uh, it's a person that has got a master in finance corporate. Uh, he works in Togo. So we got this international um, arbitrage from OHADA. It was designated by the court. That's the person that's from the committee, from the French Association, and from um, commerce from Paris, and that's a professor in Paris. So uh, we're doing this presentation. We've done this presentation, and it's just fantastic. We're going to talk about very much. We are going to start by having Jadal here. I don't know if the guy is connected here or not. We know if the guy is connected. Yeah, well, Irma, I'm going to ask you the question, and we are going to talk about the ones that work remotely. So I'm going to give you an example about evolution. Colombia has got, I'm saying they have the best lawyers I've seen, my experience is kind of long. It's arbitrage in Colombia. It's got fantastic production, and it has some good reasons. Um, this development in Colombia has been fantastic. This is, how can we imitate that in Africa, taking into account that foreign investment is growing in a very fast way? Well, thank you very much for the question. Well, thank you very much for the invitation. And I want to thank my colleagues and the ones that are online. Well, what I'm saying is, well, it is very interesting to see that historically, when we talk about arbitrage, we see that arbitrage has been developed hand, hand in hand with the development of the country. And when the countries get more money, more investments, we're going to relate that to compare Latin America and Africa, those countries, the dream continents, that's the way we call it, continents that have gotten really important amount of money that's kind of different to get in some other countries, which is also kind of irrelevant. There's something that's very, very important for the 2 years. And we got this level of investing. It's going to level up, and then we're gonna have this development in Latin America and Africa, Colombia, already had in the past in a very sustainable and sustained way. Africa is a country that has got a very important money volume of investment. When we talk about arbitrage, there's this flux of goods and services. The situation, this economic situation that we have, it means we have to have the solution so that when we have this controversy, we can just do something about it. The arbitrage has been helping countries to solve these differences. It's something very important, but we have two different stories to different situations. Uh, the investments are going up and up, so it's very good for the continent to get the money from abroad. So I want to share the circumstances in Africa. Well, it's Belt and Road. It's reminiscence from um, this land very much the silk route. And well, in the past, that used to be the same with China. Everything was good for the two continents. So from 2013, we're talking about the Silk Route. It's a very commercial route that comes from Asia, and so that goods and services are circulated in some continents, Africa, Europe, and in Latin America as well. We're talking about Africa. Africa has received very good investment from China. Well, you have to take into account that 1,000 2 million people in Africa. It's huge. So um, all this culture, all these projects. as construction, energy, telecommunication are in Africa. It means that there's accelerated growing. Potential controversies then therefore take place, and they'll have to solve that. Obviously, you have another ingredient. It's something I was telling you about. This is, the commercial route. It's happening right now in Africa and in Asia. Um, we have. It's important. Africa has got a continent. We have negotiated that regarding a free trade agreement in Africa. Africa wants to consolidate as mm, their own market. We can consolidate that. We can see and we can go up there to get this free trade agreement, free investment agreement. Uh, so many people have subscribed. I'm talking about countries, and the treaty has got some phases. The one, for instance, that generates connectivity, juridic systems that are diverse. Africa has got juridic terms, the common law, civil law as well. Uh, it's obviously it's a very nice melange. Some people in Africa, um, they want to be the best in the field. And obviously, they want to unify the way nationals of Africa can simply circulate. They have to unify that way towards the future, have their own currency. That's very important, and it's a very interesting controversy regarding some state. The investment coming to Africa can be substantiated in some statutory laws covering this free trade agreement. So I think that's kind of relevant that the future of arbitrage in Africa. It's very good if we can get this investment flow and there's some economic initiatives. It's kind of probable that in some years Africa can develop with certainty arbitrage as a contingency level, and going to see a very nice answer to talk about the vision Africa. It's pro arbitrage, and Africa is talking about its market, and some investment people can get there and be part of the African continent. Obviously, to talk about that, uh, some things regarding the African thing, the Financial Times signal that uh, direct investment went from 52,000 million to $87 billion. So it is something we have seen in the Latin American world. I'm talking about investments. We're talking about companies that invest in another country, and they go for other markets. For instance, in telecommunications, um, the goods for being consumed. We're talking about the consumer goods as well, the bed and road, the materials, the products that, the raw materials then are an obsession for China. And I think that the rest of the world and Spanish-speaking world has to had to think about Africa. Well, Daniel, we're talking about Colombia right now. I'm not only talking about Africa, but what are for you the ingredients we can talk about arbitrage. This described to a national entity. That was great. How can you convince your counterpart to join you? Because there's no jurisdiction that can favor the both of you. So I'm saying that I'm going to ask Danielle that we have the ingredients that are clue for this announcement. We are talking about Africa. We are talking about several elements, but we we've seen that it hasn't take off. So the arbitrage, the international one, is just doing very well. But we want to see something that's gonna uh, work better. Well, thank you very much for being here for this invitation. For both of us, Irma and myself, I'm extremely happy to be here, and people that are actually right here to answer this question. Well, as a Colombian, uh, obviously I have some gray hair. I can will share the fact that arbitrage was uh, it's national or international, but it's a very established figure. There's some registers regarding uh, people that we're talking about these stories from the 50s, 60s. We started with arbitrage, not to talk about people from Venice. We also talk about Romans, where there's this arbitrage image I wanted to talk about. Arbitrage was before law. Then it was the evolution that the disputes were not led by people, uh, people that obviously had some problems, and it was obviously something very well done. Um, Colombia was went from a migrant point of view to an arbitrage that was applied at the Chamber of Commerce in Bogota is kind of the oldest one, but we had to understand this international arbitrage figure, and I wanted to absorb it. So, Maria, this happened when the culture was permeated, and it was the first ingredient I was telling you about. There was a culture, international arbitrage culture. Well, we three people here, some people that are here with us, uh, are they started to say and talk about the internationalization of education. People went abroad and they just came here. They were, were practicing arbitrage, and we're starting to speak about that chronologically. It was the second ingredient. is that there was an absence, a deficiency regarding law that would take international arbitrage in Colombia. It was Tecnoquímica's case. It was that international or national. There was an intervention, but the laws from the 80s were not very good. So it was a law from 95, and we had some evolution, but since 2012, we had a law there, some modern law, 1563. 63, it was based on the model dualist system. Uh, Finally, we got this model with these two questions that were very relevant. In Africa, uh, we've seen this great step in the process of getting this arbitrage law through OHADA, for instance. It's business law I'm telling you about in Africa, and we've got 17 countries since 2018. So the second ingredient, it was second law, Colombia. We got that in Africa very, very often. The third ingredient you need um, to have a nice arbitrage. The only law is not very good, so you need jurisprudence. It's not going to happen overnight. It happens. We have to be judicialized. We're talking about the courts. In Colombia, we have internationally, we do have very robust jurisprudence, and in every country, things happen. So, in France, for instance, in America, you have that kind of thing. Uh, we have this international arbitrage, this Amangoa thing. It's kind of hot. Foreign shopping, international arbitrage. Uh, I just don't think that there's only one decision, but in general terms, what we see is the jurisprudence is pro arbitrage. And the element we were telling you about is the fact that there is this culture, um, this arbitrage forum that is solid, robust, that's kind of developed the program. It's obviously promoting international arbitrage authorization. Singapore. It is very, very important to have arbitrage center. It's kind of in premature conditions now. So in Africa, there's I think it's going very well. And also Stefania, that's right here. We have four decisions that in Africa. I wanted to close with that. In Kenya, for instance, in Kenya, we're talking about public interest. The arbitral audio, it's kind of close, so it's pro arbitrage thing. In Egypt, we have conventional things going on in Tanzania. Uh, One uh, said that OHADA is concluded that there's fraud in the subjust contract. And we can debate about that. In Nigeria, we have we can see state litigation that was, of course, and we have to talk very much about that, litigating and in a very strong pact. So those two four elements, Africa is building the right path. Thank you very much, uh, Daniel. I'm totally convinced that it's something that's going to happen. Mm, it's going to kind of happen with the countries that are working on that. It's just something that's happening right now. So I think that, it's not known, but I want to underline it. But there's statistics from the Chamber of Commerce, obviously, the United States of America are CCI, and then after that, we have this Ibero-American pact. It's Spain and Portugal. We're talking about that, and it goes beyond some countries. It's uh, it's a big nation. We uh, we obviously defend the laws we share, and we are happy to say that we have to work together. Latin America should be very kind of a pusher for Africa. Those three people are in Africa. 1966 suppose a radical change regarding protection, regarding protection for investments, regarding expropriation, and where something is happening in a very bad way. They're not paid for the fair prices, the way they treat investors, the way they treat national investors. We have legit expectations regarding the investor, and we are talking about the person doing that in that sense. The CIADI, uh, International Center for Disputes, uh, is also CIADI in 1966 is an instrument that guarantees a couple of things. Number one, it guarantees the protection of the investor in countries where, due to the economic development, there's prevention regarding the tribunals. And the way we guarantee that, and as we guarantee uh, the investor, we know that investings are going to take place. Some countries that have subscribed to the Washington Agreement in '66, they got reciprocal agreements for investings. They get more money for investing than the ones that do not have it. We've seen that they have denounced the CIADI agreement for something regarding the nation. It's about Bolivia, Ecuador. Um, Jean, how do you see this situation? Uh, how do you see the CIA thing? We have to see the proceedings, um, everything coming from Africa, arbitrage, people that are in the continent, some areas that we have some disputes going on. This is just very relevant for us to know. Africa is the unknown continent for a lot of people. Yeah, thank you very much, Jose Maria. Are you listening to me well? Can you see everything taking place now? Well, can you see my screen right here? I don't think so. We are happy to that you know that something's taking place. The role of Africa is very much regarding the CIADI. The African states participated actively in a negotiation. CIADI negotiation was a very innovative product, and we had to create a mechanism, an institute that was impartial, independent, that allowed people and investors to go to the arbitrage and conciliation to reconcile their differences regarding investings. So apart from the negotiation, they had a very important role for it to come into terms. The African states that I don't know if you can see the slides. I think there's 46 states, African states, and it means that African states, their members, represent the 30% of the other members and 30% of the votes. The administrative state, CIADI, it's about uh, the organ is just there. It approves the arbitrage rule and also conciliation. That's the second part, the implication of African state for foundational causes, jurisprudence of CIADI. There's an example, an important one. It was based on investing contract, and it was very much regarding investing law. Those were cases involving um, African state, against Morocco, and the other one against Egypt. There's this tribunal jurisdiction that was based. Uh, Following this jurisdiction, we had a great impact there. Uh, it was decided by a president and a co-president that were in Africa. So in these cases, in SPT and APL, it's very much so arbitration without community. That's the way you call it. The idea that a state can uh, go and do a unilateral offer and go forward, and then the investor can basically accept the arbitrage paper they want to work on. It's a very, very important role in the jurisprudence atmosphere. Uh, Investment, innovation, those states have been the one taking the lead regarding transparency proceeding, following what the good example, Guinea against another state. The parties were very well, they agreed to apply certain transparency rules that they were new, and there was a very high level of transparency. Another illustration, yeah, it's a very innovative case. Obviously, it's the participation of these states by the African Union. It was very, very good and ready to follow the CIADA rules. We have seen these arbitrage rules. Uh, the amendments we did there, the participation of the states cannot be underestimated. Uh, the second part of the second aspect regarding Jose Maria's question, statistics. I wanted to check this number. Uh, the 30th of June this year, this CDA got many, many cases, 138, so 22% of these cases involved some African states. It's a very important portion regarding uh, South America. Talk about Europe, we talk about Asia as well. Here we see the base of that agreement, consentment. We can establish the jurisdiction of CIADI. We have some characteristics that are kind of different to implement African states. In global terms, there's a graphic here. The majority of cases, it's about multilateral and bilateral cases. Many, a very high percentage is bilateral, and others are multilateral. So we can reach 76% of the cases. This is very, very important for the investing treaties regarding the ones taking place globally. We got the cases. Um, we see that this investment treaties is under 50%. So the portion of cases that's regarding contracts is kind of high, 50% for laws, 36% is very much regarding the contract. Now we check the sectors of the economy. Obviously, we can see that petroleum, gas, and oil is 25% of the cases, and electricity and so the importance of the sector. Talking about energy, renewable energy in Europe, that's a very important case. So the cases we see in African states is very much kind of different. The oil, gas, and minery is very, very important. We're talking about a big portion, that's 36% of the cases. So the second sector in investment is construction is maybe 6%. Now I want you to check this regarding the results in the cases regarding important things taking place. We compare that by regions. Uh, there's the graphic on my left. We compare that by regions. The number of cases in Africa is kind of low. Are the refs for the West Africa, South America. mm, we have 20, 40, and 60% of the people named there. The parties get the majority of the refs. We have many, many refs in the country. We have this on the right hand of the screen. We see that the CIADI wanted some other refs in the countries. We can basically compare that in South America. We have the CIADI that's kind of 142, and the rest is just right there. In this situation, the CIADI takes the initiative to get this diversity, regional diversity. That's with expertise that's needed, initiative that can come and can propose things regarding the list to get the tribunal person. Um, obviously, the density. Obviously, the European Union or the arbitrage in Africa. So that's very, very important. We talk about jurists, arbitrage to contribute the CIADI as well. And it's published in 2019, a very important number of Africa and the CIAD. I'm gonna finish right now. I'm sorry for the avalanche of numbers and percentages. We are going to finish with the results of the cases. We have then see the percentage. Mm, 34% of the disputes, of the differences, are very well solved by the tribunal. This percentage goes up. Regarding the European states, we go up in 45%. We see the cases that are decided by the tribunal. So, for example, a case was set. There's an audio, for example. We can see an equilibrium, a balance. The results are just there globally, and the numbers are very much linked to the global stage. It's 47% that go claiming of the donors, and 53% rejects the claims, for instance, of the jurisdiction. These cases, we're talking about African state. 51% of the cases with these last statistics, I finish my presentation. Thanks a lot. Thank you very much, Pedro. Your information was great. Everything we can do to get the situation in Africa is just little. I'm happy to see your statistics because there's a number of the referees coming from Africa are in the third position. So Mexicans are in the North America. Obviously, it's something very, very important. Uh, and people that practice arbitrage should know that. Uh, we see that as a very far away continent, but in the arbitrage thing, it can be relevant. Uh, we are trying to get refs from the African continent, and then we stop suffering from the designation. The last one we have now, we have Marcial Akakpo. Marcial is an expert in the organization of the commercial rights in Africa, is OHADA, and it's an organization in Africa, for instance, that has got uh, fundamental mission, the cohesion of the members. We have 17 members distributing integration and do something very, very similar regarding what happens at the UN. All of the directions then from the European Union. We are going towards a juridic system that's the same for all of us, and of course, we have to foment investments and something that's very, very stable in the African world. Marcia, I'm going to ask you. It's a ref and a lawyer in Togo, an expert in that world. So, Marcial, como
Esto es una jurisdicción que tiene un centro de arbitraje muy reconocido en la región, con árbitros que se toman el tema muy seriamente y se están preparando, pero además están preparando las nuevas generaciones que van a estar interesados en participar en el arbitraje en África. En esa jurisdicción se hablan de temas tan interesantes como la innovación y la diversidad en el arbitraje, y así lo afrontaron durante la época de la pandemia. Y finalmente, Mauritius está haciendo todo un esfuerzo importante desde el punto de política pública y se ha convertido en una sede eh, pro arbitraje. Eso ha ayudado a que el método se esté desarrollando de manera muy importante en ese país, y adicionalmente que varios países, no solamente de África, sino de Europa y algunos latinoamericanos, estén tomando como ejemplo algunas de las buenas prácticas que se están dando en esa jurisdicción.
Pues muchas gracias, Irma. Y ya voy a concluir reiterando un poco lo que decía al principio. Arbitraje y Estado de Derecho, rule of law, es algo que están íntimamente unidos. Por otro lado, las inversiones tan necesarias para muchos países en subdesarrollados o en vía de desarrollo solo podrán ser atraídas si de verdad los inversores tienen la seguridad de que su inversión va a estar protegida. Y afortunadamente, a través del Banco Mundial y de los tratados internacionales, en este momento tenemos los mecanismos para que eso sea así, para que cualquier inversor sepa que si surge algún problema con su inversión, se le va a aplicar el derecho y solo el derecho. Estamos en un congreso sobre la prevalencia del derecho sobre cualquier otra circunstancia y, por tanto, a través de estos mecanismos, el derecho va a ser aplicado. Y África, desde luego, necesita muchas más inversiones no solo en este momento, como nos recordaba Irma al principio, provenientes de China, sino de otros muchos países. África es un continente que tiene que desarrollarse y, en consecuencia, todo lo que hagamos por potenciar la inversión y por potenciar el arbitraje, pues será poco. Muchas gracias a Paul Jean, Irma, Jalal, Daniel y Marshall por habernos ilustrado esta tarde, por los que
Muchas
estáis
gracias.
físicamente aquí hoy y por los que estáis en este momento en París. Muchísimas gracias y cerramos la sesión.